Welcome to our video series, Data Act Unlocked. In this series, we provide a concise overview of the most important provisions of the EU Data Act. In this episode, we will take a look at the protection of trade secrets. We will show you how companies under the EU Data Act can protect their trade secrets in spite of data access requests, because a mere claim to trade secrets is not sufficient for refusing such requests. The core objective of the EU Data Act is to improve access to machine and system-generated data. The basic idea is that users should be assigned the data they generate through the use of IoT devices and connected services. For this reason, users should be given the widest possible access to and use of this data. In addition to the principle of access by design, the EU Data Act provides for far-reaching data access rights. Article 4 of the EU Data Act grants users free, easy, and secure access to the data they generate. Article 5 of the EU Data Act allows users to share this data with third parties. The data covered by the right of access may also include trade secrets, such as technical know-how, sensitive system data, or information about operational processes. This raises the question of how the right of access can be reconciled with the interests of the owner of the secret. When is something considered a trade secret within the meaning of the EU Data Act? A trade secret exists when the information is neither generally known nor easily accessible, especially not for people who typically deal with such information. The information is protected by reasonable confidentiality measures by the lawful owner, and if there is a legitimate interest in keeping them confidential. But how does the Data Act protect such trade secrets, and where is the line between disclosure requirements? There is no blanket right to refuse access on the grounds that trade secrets are involved. Under the EU Data Act, data must generally be disclosed even if it contains trade secrets. There are essentially two protection mechanisms available for the protection of trade secrets. Data owners may require users or third parties to comply with certain technical and organizational measures to protect confidentiality. This may include, for example, confidentiality agreements known as NDAs are concluded. Access to the data is technically restricted. Only a small, precisely defined group of people may access the data, according to the need-to-know principle. Standardized contract clauses are used. Furthermore, the use of the data is documented and logged. If these protective measures are not successful, the data owner is entitled to refuse or suspend the transfer of data, but only if no agreement has been reached on appropriate protective measures, agreed measures were not implemented, or there has been a breach of confidentiality. In such a case, the data controller must justify his decision in writing and inform the competent national authority. In limited exceptional cases, the EU Data Act also allows access to be denied, even if protective measures are in place. According to Article 4, Paragraph 8 and Article 5, Paragraph 11 of the EU Data Act, the data owner may deny access if, despite all protective measures, there is a high probability of serious economic damage. According to the recitals, such damage is likely to occur if the disclosure of the data is expected to result in serious and irreparable economic losses. It therefore depends on the one hand on the economic significance of the data and on the other hand on the risk of it being misused. An important aspect here is whether the data will be transferred to a third country where IP rights are practically unenforceable. The data owner must also provide concrete evidence of the imminent damage and immediately justify the refusal in writing. This exception requires a specific risk analysis and careful examination. Anyone who wrongfully invokes a right of refusal runs the risk of violating the EU Data Act. What does this mean in practice? Companies must analyze their data structures and determine what data is subject to the EU Data Act, whether the data contains trade secrets, what protective measures may be taken in accordance with the EU Data Act. At the same time, it is advisable to establish internal processes in order to be able to respond appropriately to data access requests, both technically, organizationally, and legally. To wrap up, here are the key takeaways from this episode of our new series, Data Act Unlocked. The EU Data Act creates new access rights, but not an unconditional right to insight into corporate know-how. Anyone who wishes to invoke the protection of trade secrets must demonstrate this in a comprehensible manner, secure it through appropriate measures, and fulfill the requirements of the regulation in a transparent manner. We're glad to have you following our series, Data Act Unlocked. For more insights, check out hashtag CMS Data Law or visit our website.